Okay, here we go. Okay, welcome everybody to the Wednesday, August 5th, 2020 Design Review Commission meeting. Could we have a roll call, please?
Yes, Commissioner Krilling.
Here.
Commissioner Valia.
Here.
Vice Chair Case.
Here.
And Chair Killian.
I'm here.
And for the record, Commissioner Gorney is not with us, and I'm assuming that he's out for the evening.
Okay, well, let's get this legalese out of the way. Pursuant to the governor's executive order, city commissioners may participate via teleconference. Teleconference locations are not open to the public pursuant to the California governor's executive order. Now, if the public would like to participate, the web in our ID is 915-0784-9742, and the login password is 999727. And then if you'd also like to join by phone, the number is 1-669-900-6833. Okay, so we're going to move on to item number 2, which is the consent calendar. And we have nothing on the consent calendar, so we'll move on to item 3, which is public communications. And this is an item for anybody in the public that'd like to make a comment on some item that's not on tonight's agenda. So again, I know there's a 15-second delay for anybody that'd like to participate, so we'll give the public a chance to weigh in now.
And Mr. Chair, while we're waiting for that delay, I did hear from Commissioner Gorney. He is trying desperately to join us right now.
Okay, so maybe we'll stall a little bit and give him a chance to join us.
Behind you. Behind you. Carolyn Jackson. Let's. This is your public comment that you sent in.
Are you getting anybody from the public on a public comment?
Not getting any, Mr. Chair.
Okay, let's close that and move on to item number 4. Actually, we have 2 items. One is a public hearing, which is the Waymark building, and we also have a commission considerations, which is item number 5. I think we are going to switch those, and if that's acceptable to the rest of the commission, we will hear item number 5 first, which is the a staff report on the state housing laws.
Yeah.
Okay, hearing no objections or comments, I guess we'll go to a staff report. Is that, or are they?
That's right, Mr. Chair. Hang on, we're bringing up the presentation.
Okay.
And Claire, live from the city attorney's office, will be making the presentation along with Brian Hickey from city attorney's office as well. If you just hang on a minute. Bear with us.
All right.
In the meantime, if anyone knows a good barber, please let me know.
Are they allowing them to cut outside, or?
They will be as soon as the county allows it. Yeah.
Well, I have an update. The county does allow outdoor haircuts, and the city council just approved to allow that to occur about 2 hours ago in Walnut Creek.
Oh, good.
Oh, nothing like the most recent updates, up to date. Okay, looks like we're ready up on screen.
All right, I'll kick it off. Good evening, commissioners. I'm Brian Hickey, one of the assistant city attorneys, and also tonight, Claire Lai is with us as well. And Claire and I are going to spend a few minutes discussing SB 330 and providing a a brief overview leading into the later discussion of objective design standards. SB 330 was enacted and became effective on January 1, 2020. As the commissioners are aware, housing's been a primary focus by the state legislature in recent years. And during the 2019 legislative session, more than 20 housing bills were enacted to become effective in 2020. So you could say that housing is one of the top priorities of the state and has been now for a few years. The nature of the bills enacted in 2019 kind of run the gamut. Some are laws affecting municipal control over housing development, and SB 330, which we're going to talk about now, is probably the primary bill that was enacted last year. There were a list of other laws enacted, some dealing with ADUs, some dealing with the density bonus law. But the general theme is basically increasing the housing supply and promoting affordable housing and promoting housing in general, and making it easier to run the gauntlet of submitting an application and having housing approved. So that's sort of the general theme of all the bills. And again, arguably SB 330 is the primary bill. So jumping into SB 330, what does SB 330 do? From a 30,000 foot level, it's designed to limit the city's ability to regulate or deny a housing project. It applies to affected cities, which at first blush you might think is a limiting list, but I think of the 482 cities across the state, 445 are deemed to be affected cities as defined by State Department of Housing and Community Development. So, any city throughout the state is basically an affected city unless you're really out in the rural areas of the state. So the Bay Area, Contra Costa County, and Walnut Creek are affected, are all deemed to be within areas that are affected cities and therefore subject to SB 330. And what SB 330 does is it amends the Housing Accountability Act. And that's a set of laws that was enacted back in the 1980s. And again, generally constrains a city's ability to deny housing projects to the extent they're otherwise consistent with a city's previously enacted general plan, zoning requirements, and other development regulations. So if a project complies with, again, general plan, zoning, development regs, then SB 330 is designed to promote its timely or efficient approval. And this sort of latest development is just another add-on to this previously established law. With that in mind, and let's go to the next slide. So what does SB 330 really prohibit? And what it prohibits is it prohibits the creation of new policies or the enforcement of existing policies that would do any of the following. So first, anything that would change the zoning designation to a less intensive use. So think your classic down zoning. With respect to property that's already residentially zoned, it prohibits down zoning of that property. There are some exceptions that we'll talk about, but generally speaking, you can't down zone property. It also, yes, sir.
I just didn't, how would you like us, if we have a question, would you like us to hold it to the end or pop in here? I don't know how long your presentation is going to be or how you'd like us to interact with you.
Sure. I think generally, if you've got questions, feel free to raise hands and ask. That's fine. I think our presentation is only about 15 minutes or so. So if that leads you to want to hear it and then ask questions, that's fine too.
Okay, all right.
So now I'm waiting for a question.
Well, I'll wait now. I just, this it kind of rang a bell on a question I had, but I'll just wait so I'm not
Okay,
interrupting
okay.
the rest of your presentation.
If anyone has a burning question that they don't want to wait on, feel free. So under 1A there, basically you can't downzone property. The second point there is that you can't adopt a housing moratorium that would have the effect of reducing the potential housing stock. And then next slide. And then third, and something that will get talked about later in the evening, is it prohibits the enforcement of non-objective design standards. And I know the commission's had prior discussions regarding objective design standards. And I guess I'll read it. Objective means no subjective judgment, uniformly verifiable. So as we've discussed before, it's standards that would be on a checklist and that somebody could basically take a look at that list and make a determination. And so it prohibits enforcement of standards that are not objective. And then fourth, or D down there, is it prohibits the adoption of growth control ordinances or restrictions. So think, for instance, Measure A, it would prohibit a voter initiative that would have the effect of reducing density, reducing housing stock, reducing the development potential of property. So Measure A, which is currently in effect, SB 330 would allow the city to still regulate under Measure A, but a measure like that could not be enacted going forward through a voter initiative. So that's another no-no under SB 330.
So Brian,
Yes.
this is Charles here. Could you just quickly give an example of what might be a classic subjective design standard that you might hear that we won't be able to do anymore?
Sure. So a design standard that says that let's see. The
What about
development
plan?
shall. Sorry, excuse, say that again.
I was saying, what about a site plan where we didn't think it was a good site plan, and to make it work, they might have to relocate or maybe lose one housing unit because the site circulation didn't work? Is that subjective, that we wouldn't be able to do anymore?
Sorry, repeat that one more time.
Well,
I can give an example
Sure.
if that's
Is that
helpful.
Janine?
Yeah, that's Janine.
Sure.
I'll put my video on. Basically, a subjective standard might be something along the lines of the material needs to be compatible with the style of the building, or the building needs to be compatible with the neighborhood character, right? Versus a standard would be something along the lines of you need to space benches no more or at a minimum of 20 feet apart, or benches must be black.
So I was going to say, so you would not be able then to have an objective standard that might say something like, the architectural design of the building must fit within the neighborhood it's being built in. You wouldn't be able to do that?
Correct.
So
And
you
we're
could-
going to get into that,
Okay.
Haley and myself, in the next presentations. We'll give you some more examples, and we'll have more opportunity to kind of get into the weeds a little bit more
Okay.
on
Great.
standard.
Okay, thank you.
Thanks.
Let's go to the next slide. So another prohibition under SB 330 would be that you basically can't lose units on an existing housing site. So you can't approve a project that would demolish units that doesn't replace the site with the same number of units, or at least the same number of units. So again, with the overarching goal of preserving existing housing and not reducing the existing housing stock. And then there's also a concept under SB 330 of protected units, and those are units that are either formally regulated as affordable housing units, or units that are in actuality occupied by persons or families that are designated as lower income. And so with respect to those protected units, there are additional requirements to replace those units, and to so you've got to replace all protected units. You've got to include the maximum number of protected units that have been on the site over the past 5 years in the new development. And then you also have to allow existing residents to stay in place. If you're going to demolish and build a new project, you've got to allow existing residents to stay in place until 6 months before construction. And then the developer is also required to offer relocation benefits or a right of first refusal to occupy a similar unit at those lower affordable rental rates. So those restrictions are in there as well. So again, designed to kind of protect existing housing and not, you can't demolish 40 units and build a new development with 30 units. Next slide. So this is sort of the confirmation of what you still can do under SB 330, and we talked a little bit earlier about you can enforce previously in effect prior to January 1, 2020 voter established regulations such as height limit, Measure A, and other initiatives that are already in place. You can still require compliance with CEQA. You can still, we talked about not being able to downzone earlier. And the caveat to that is now you can downzone you can downzone residentially zoned property, but you basically have to make up for it in another part of the city. So there has to be no net loss of buildable capacity in your zoning ordinance. So
when you say downzone, do you mean going from 4 houses to 3 houses?
Right. So think of like an area that's zoned, multifamily high, and you have a certain number of dwelling units per acre. You can't then change that zoning district to multifamily low with a lower amount of units allowed to be built on the site. And so if you do that, if the city does that, they've basically you've got to zone somewhere else and increase the amount of buildable units so that it's evening out. So you can't have a net loss in residential capacity under your zoning ordinance. And I think I'm going to transition. Claire's going to talk a little bit about SB 330 in the context of a specific development application. So I'm gonna transfer or throw it to Claire to kind of go into the weeds a little bit on specific development applications and the application of SB 330 to a housing project.
Thanks, Brian. If you could have the next slide. Thank you. Good evening, commissioners. I'm Claire Limes, Assistant City Attorney. So I'm going to talk a little bit about the Housing Accountability Act and how that's been changed by SB 330. The Housing Accountability Act is a long-standing law, as Brian was saying, but it hasn't been utilized in recent years by applicants and project developers very much, but it's recently been amended twice by the legislature, once in 2017, which changes went into effect in 2018, and then once again in this past session as a part of SB 330. And the goal of the Housing Accountability Act is really to address the shortage of housing by restricting how local governments can deny housing projects and to lower densities for housing projects. And because of these changes, it's likely that the law will be more noticed by the development community, and we expect that it be utilized more often than it had been in the past. And so the principle under the HAA is that if a housing development complies with all objective general plan, zoning, subdivision standards, and other policies, regulations at the time the application is deemed complete, then the city may only deny the project or reduce the project density if there would be a specific adverse impact to public health and safety, and there's no way to mitigate that impact. And so SB 330 changes these components to further restrict local government's ability to impose these regulations and to deny projects and require them to comply with different standards. And the HAA does give the court the ability to impose sanctions and fines for non-compliance. Next slide, please. Could we have next slide? Thank you. So I'm going to talk about what kind of projects are covered by the HAA and what projects we have to do to get the benefit of this law, and what changes were made by SB 330, and what happens if a project is subject to the HAA and does qualify to get the protections, if you will, under the law. So the HAA applies to housing development projects, which is defined as any of the following: one, residential units only, or mixed-use projects that's where at least 2/3 of the square footage is designated for residential use, and also transitional or supportive housing. Again, the intent is to really pick up these housing projects where housing is included, and then restricting local authority to deny them or to approve them at a lower density. Next slide, please. So this table is intended to summarize the most significant changes by SB 330 to the Housing Accountability Act. And there are 4 areas, as you can see in the most left column. The first one is changes to objective standards. As we were discussing previously, there was no definition about what constituted an objective standard, but now it takes on the definition that Brian had mentioned in the beginning of the presentation. Also, it's the same definition under SB 35, where there's streamlining of affordable housing projects. And basically the definition is that you cannot have in your standard a personal subjective judgment component. You can only have something that can be verified against a benchmark or some criteria that is known to the applicant, known to the city, and it's publicly available that everybody can check against it and verify whether or not there was compliance. And also SB 330 changes what objective standards the city may impose and when the application can lock in those standards. So the next 2 rows are talking about these changes, and they're really intertwined as a part of the same step. So previously, the city could impose objective standards at the time an application is deemed complete, and the definition of deemed complete back then means that the project has submitted everything that's on the city's traditional planning checklist. And that checklist, as you are aware, is the list that's required under state law, and it's required to be published, and it's used by the city to verify whether or not it has the information that it needs to determine whether the project meets its standards or not. But now SB 330 changes that and says the city can only impose objective standards that are in place at the time of a preliminary application submittal. So that is a new term. We'll talk a little bit more about it later. But a preliminary application is a new concept under SB 330, and it's basically a list that the statute says these are the only items that the city can include and ask the project to provide, and you basically just check it off. And if the project submits the list,
they then lock in the standards and policies at that time that would later become applicable to them. And then finally, the statute gives the court more options to impose sanctions if the city does require a project to comply with standards that are adopted after they've submitted a preliminary application. Next slide, please. Okay, so what does a project have to do to be covered by the HAA and get those benefits of the statute? One, it has to be a housing project. So as defined above, it has to be either a residential units only project or a mixed use projects with 2/3 of the square footage being residential or a transitional or supportive housing project. Also, it has to submit a preliminary application. And then after it's submitted a preliminary application, it has to submit the traditional planning application within 180 days. And then when it locks in those standards, at that time, it has to comply with the applicable objective standards that were in place when it's locked in. And so next slide, please. And so again, a preliminary application, it's a new concept. It's created by SB 330. And it's basically a list of 17 items or so that the law says this is the only things that the city can require a project to submit in order to lock in the applicable policies and standards at the time of submittal. So the city basically checks off the item. It doesn't determine whether or not the information is sufficient. If the item is present, then it's considered submitted as a part of the application. So some examples include project location, proposed land use, the site plan, density bonus requests, waiver requests, subdivision approvals, parking spaces proposed, BMR units, so things that are listed in the statute. And again, once this is submitted, the applicant can lock in the standards that are in effect at that time. Next slide, please. And so in order to take advantage of locking in the standards at the time of the preliminary application submittal, the developer has also to submit a complete application based on the traditional planning application to make it more complicated. They have to do that within 180 days after filing the preliminary application, and then they have to commence construction within 2.5 years of the final project approval. So essentially, if the developer submits the preliminary application and doesn't do either of those things, then the city can come back and impose standards that are adopted after their preliminary application submittal. And they're just a change of term by SB 330. Previously, submitting a traditional planning application is called deemed complete, but now you'll see that it's called determined to be complete, and submitting a preliminary application is now deemed complete. So basically the law is pushing back the time by which the applicant can lock in the standards, and it makes it easier for them to do that, provided that they comply with these subsequent steps later on. And next slide, please. So if the project does all the steps to be qualified under the HAA, what does the city have to do? One, it must notify the applicant whether the project is consistent and compliant with the applicable standards, the objective plans, standards, policies that they have locked in within a certain amount of time after they've submitted the traditional planning application. So for projects with 150 units or less, the city has to provide that notification within 30 days from submitting the traditional planning application. And then for projects with more than 150 units, then the city has to provide that notice within 60 days. And the city really has to determine whether or not the project is consistent with the objective standards. If there's evidence that will allow a reasonable person to conclude the project is consistent. And so that is a pretty, the bar is pretty low for that, because even if there are other evidence suggesting that there may be inconsistencies, as long as there is substantial evidence that would allow somebody, a reasonable person standard, to conclude that there is consistent, then the city then would have to determine that the project is in fact consistent. And if the city fails to provide us notice within the 30 or 60-day time period, that the project is automatically deemed to be consistent and compliant with the standards that they've locked in. Next slide, please. So what happens if a project is deemed to be consistent and compliant with the standards they've locked in? The city cannot deny or impose conditions that lowers the project density unless it makes certain findings. So the first finding is that the project would have a specific adverse impact on public health or safety. And the second finding is that there is no feasible method to mitigate or avoid the impact. And the statute does define what a specific adverse impact would be. And it has to be something that's based on objective public health standards or safety standards. And it can't just be something that the city sort of describes and vaguely and says, we think that this is a broad impact or it's a violation of the zoning code. That does not constitute such an impact. It would have to be something that's verifiable. It's based on public health standards, and that's open and verifiable by the public. Next slide, please. So the city would have to make those findings if it wants to deny the project or lower the project density. But lowering the density doesn't just mean reducing units, it means imposing a condition that has the same effect or impact on the ability of the project to provide housing. So there's no definition about what this might mean, but it's really broad based on the text, the way it's written. So essentially it could include having the project lose a unit or reduce the number of bedrooms or potentially raising the cost of the project so that its ability to provide housing is impacted. The city's finding on the previous slide must be made by a preponderance of the evidence. So that means the majority of the evidence in the record must support the finding. So it's not just that there's evidence in the record to support it, but the majority of the evidence that's contained in the record must support the city's finding. And next slide, please. And so what happens if the city violates the HAA? The statute gives the project applicant and housing organizations to the ability to sue the city. So it gives them a cause of action to do that. And the court, if it finds that the city has violated the HAA, it can impose sanctions, fines, or it can overturn the city's decisions and the conditions of approval associated with the denial or with the approval. And it could also issue the building permit in the city's place. For example, if the city fails to comply with the court order to overturn one of its conditions, the court will have to impose a fine, and the fine is a minimum of $10,000 per unit in the project. And the fine does go up if there's further bad faith or other violations. So I'm going to turn it over to Brian to just finish up the SB 330 components.
Claire, I thought you were going to take it home there. Yeah, basically, and Claire's already touched on it. The consequences are that any interested person can file suit. So it's not just the developer that has a cause of action, but housing organizations, any other interested person can, on behalf of the developer or on behalf of a housing organization that is promoting housing stock or affordable housing, can basically initiate a lawsuit against the city for violation of the of SB 330. And as Claire mentioned, court can impose sanctions minimum of $10,000 per unit. And let's go to the next slide. And then the other one of the other interesting and important parts of SB 330 is that cities are now limited on how many hearings they can conduct on a proposed project. So everyone kind of knows the examples of certain projects where you have multiple hearings at different commissions at the city council. That now under SB 330 would not be allowed. So if a project again comes in, is compliant with the requirements of SB 330, the city's limited to 5 hearings. So it's another attempt to kind of streamline the approval process. City has less time to approve at a project after certifying an EIR. This isn't really an issue for the city. Generally, the city, most projects in the city of Walnut Creek, the final EIR and certification of the EIR comes at the same time and at the same meeting as final approval of the project, but it doesn't always have to. And I think the prior law was that you had 120 days to approve a project once the EIR was certified. I think that time's now been shortened to 90 days. And so next slide, and then that might be it. So I guess Claire and I are available for questions.
Wow, this sure seems to be written by lawyers and not design. So anyway, from the commission, are there any questions? Charles?
Yeah, there was the one slide that it talked about, it was just a few slides back, and it talked about, you can't impose a condition that might increase the cost of the project. That would, and I can't, I'm just thinking about going back to my first question about architectural style and construction materials. Yeah, if you want to go, it was way towards the end of the presentation.
I think it's like 15 or so.
That one. Increasing project costs. I have trouble believing that the legislative intent would allow something. I'm just going to make this up. It's in a area that's zoned for multifamily housing. Great. There's other multifamily housing in the area. It's a beautiful brick veneer, a nice architecture. I'd worry about under that sort of language that, I'll just be a developer and I'll come in and say, well, I'm going to put up a building with plywood exterior siding and I'm going to paint it white and call it a day. And then if I say, yeah, but we really need the brick and nice things to fit in with the rest of the multifamily housing units, are they going to be able to go, well, yeah, but that makes it more expensive. So under the law, you just get plywood and white paint. Something
Right.
seems amiss in how we're characterizing that. And I'd be really concerned if that's what the legislative intent was.
I think, and I'll let Claire elaborate. I mean, I think the intent is that those types of things have to be already baked into your development regulations, and they have to already be baked into your objective design standards. So you can have objective standards that go towards those types of issues, but they've got to be, for lack of a better phrase, they've got to be on the table up front and at the time that the application's filed. And they can't be imposed later in kind of an ad hoc way.
Yeah, I'm gathering from when I read this and prepping for the meeting, the city needs to be very thorough in crafting its objective design guidelines. They probably need to be much more robust than they probably ever have been in the past, because I think you can take almost any situation and like architectural style fitting within the neighboring architectural style, where you could start to list, if the area you're going to build is, Tudor style, you have to do a Tudor building, etc. You can get things very specific and they're very objective. And I think unfortunately, we kind of have to think of all the what could go wrongs when we come up with these guidelines, so that if we think about the what could go wrongs, we try and put something in that will be objective to prevent that thing from going wrong, so that, you know, we can play by the rules yet still get this housing built for people, yet have it fit into the city's, you know, overall appeal.
Right, and
And
you bring up a really good point. Sorry, Brian.
No, go ahead, Claire.
But no, if you look at the whole changes from SB 330, the limit on 5 hearings and on design guides, it really is intended to capture, you know, those jurisdictions where the housing project goes through multiple rounds of review and it never really, the approving body never really states what it wants. It just gives you kind of a vague description of what the architecture should be. But I think if the city does have that, the standards crafted in an objective way. I mean, the law does allow for that, but it's really intended to capture that kind of endless reviews and then to make housing approvals faster.
Got it. Thank you.
I have a comment, and it's that with this HAA, I think we will have to restructure the design reviews role. I don't see us following our regular role here anymore when it comes to housing projects.
Right, and I think in the next item, or the companion item to this, planning staff is going to talk more about objective design standards and kind of the evolving role of the design review commission based on some of this legislation.
Okay, are there any other questions? I have a couple. Brian, what about are the other assembly bills, for example, from landscaping now, we have to adhere to WELO, which is the Water Conservation Guidelines. Is that automatically applied to this, or what happens if an application comes in and doesn't address WELO? Are we allowed to say you have to do that, but it may alter your project?
Sure. Developers will still have to comply with all applicable laws, and so other requirements that are out there through other legislation will still need to be complied with. And yeah, that would be a basis to say, you know, you've got to go back to the drawing board.
Okay. And can Walnut Creek ever achieve a certain number to where they're not being penalized because they have 100% of the housing and maybe Lafayette is only doing 10%, to where Walnut Creek says, okay, we've got our fair share of under this law?
Claire, do you know, under SB 330, I think the short answer is no. Under some of the other housing legislation, the requirements are tied to kind of where you are with respect to your RENA numbers and where you are with respect to actual development as compared to potential development within the community. I don't know if
these ones don't count for that. They apply regardless of where you're at with your RENA numbers. There's some other, for example, there is the no net loss set of rules from 2018 that does tie to your RENA numbers and whether or not you've issued enough building permits. For example, SB 35 also ties in, but these ones don't do that. And so they just apply regardless of where the city is at.
Okay. And there was something earlier on that said you cannot, you know, if you have 4 homes on a property, you can't come in and put 3 homes. The city can't, say you can lower the density, I guess. Does that apply to the applicant also? I mean, what if an applicant owns a property that has a house and 2 small homes and he wants to create just 1 home for himself? Can the applicant do it? Or is this only applying to the city not lowering the density?
I think in that case, that would be an example of that. That's a project that could not be approved based on the fact that you're taking 3 units and now pursuing a project that would turn that into a single residential unit.
But the applicant, there is a way for the applicant, if he wants to do that, he could do it. It's just a different path of approval.
Right, just not under SB 330 and not under a streamlined Well,
see.
I don't know, Claire, would,
I mean, I guess either you could look at it as they're not compliant with the zoning provision, that's the zoning deck, or the units that's allocated to that lot, and therefore you don't get the benefit of the provisions of the HAA. But otherwise,
Okay, so, but there is a way then. We're not forcing the applicant if that's not their desire. They do have an option.
but I think that it's just the city has to make clear that it's not us making that requirement. It's something that the applicant wants to undertake.
Okay.
right,
Now, state also going to be forcing objective standards on the city?
No, I'm not sure what.
Well, how much leeway does the city have to come up with our objective standards? You know, that if we want a, certain neighborhood that has a Victorian style, you know, that they have to have Victorian lampposts out front. Can the city put those type of standards in, or again, are there now more restrictive standards from the state that's basically going to eliminate any design at all? And it's just, you know, if you got 4 windows in a wall and 4 walls, you know, that's a house, and you know, throw the design out the window, so to speak.
I think that the
So
short,
essentially, if you want to achieve the design, you have to articulate it in an objective way so that you can achieve the kind of look that you want it, that the city would want to be seen in the neighborhood. So, you know, if something that was originally subjective and it just says compatible, it just depends on compatibility, then the city would need to think about that, how to turn that into something that's objective and can be articulated in that way.
Now, I would think going through all this, that I would want to say, okay, let's make our objective standards more restrictive. If we don't, we have no recourse if it's a lousy design. So it now almost means, you know, let's throw the whole kitchen sink into the objective standards to make sure we're not forgetting anything. So I'm not.
and I do think,
Go ahead.
no, I was gonna say, and I do think that specific issue will be addressed by planning staff as we get into a discussion of objective design standards going forward as well. So they have a presentation, and I think they will be hitting on some of those issues.
Okay. Joseph, I see you're here. Do you have any questions? You came late, or?
Yeah, I got a couple. I'm going to stay away. Can you hear me, by the way? Can you
Yes.
hear me?
Yeah.
Okay, good. A couple, now there's 180 days to, quote, submit the complete application, according to what we just heard. My experience is we always have that 30-day, we submit the application, city has 30 days to look at it. It's never complete. We then go back for 15 more days and do more work and submit it again, and it's still not complete. What is the city's obligation to have to, you know, do a reasonable review in 180 days?
So the 180 days, it's the time from you submitting the state mandated items to submitting cities requiring. And so the city's process for reviewing the items that it requires doesn't change. But you just have to follow, you still have to, that requirement is in effect now. We follow the 30-day timeline now. So that doesn't change. You just have to tell the applicant whether or not the application is complete, whether or not it's missing items from your planning checklist. So that won't change.
Okay, but does the city have an obligation to get it done in 180 days? Because my experience is, you know, there's always new things or different things that the city wants that makes that, you know, initial application just sort of take forever to get actually finalized.
Right, and that round of review won't take place until after the 180 days, after the 180 days passed. because
Right.
they
Okay, I'll have to ask this one individually, because my experience is it never takes 180 days. That not your city, of course, but other cities always come back with new requirements. And what about this in your traffic report? What about this over here? You're missing this. We need more information. And then another 30 days goes, another 30 days goes, and 180 will disappear in no time at all. So I'm just wondering, does the city have an obligation to be able to work in that 180? And if they don't deem it complete, are you automatically complete?
No, I think the 180 is really designed to work the other way, which is it's really a little bit of a backstop on preventing a developer from submitting those initial checklist items and locking in the entitlements and then sitting on the application and not pursuing it. So if you're a developer and you file an application and you don't pursue and those 180 days lapse, then you basically lose the benefit of what you had locked in under that preliminary checklist.
Okay, so it's more for the developer, not for the city that has. Okay, I'm
To
sorry.
have to get it done within 180 days, correct?
Okay, they have a limit of 5 hearings, and if you look at the BART project and some others, we've had 35 hearings. If the developer comes in and wants to make changes to the project, that would not be included in the 5 hearings, correct? With BART, it went on so long that they came in with a whole different architecture. So we had like 3 more meetings just because they decided to make architectural changes. So you're saying the city can only require 5 hearings?
Correct.
I mean, it's a fuzzy one. I'll have to ask that. I don't want to take the whole public hearing on it.
And again,
it's
I was just going to clarify that the 5 hearing requirement would only really apply in an example where the project is otherwise completely compliant with general plan, zoning, etc. So if you're coming in and you need a rezone or you need a general plan amendment, you're sort of trying to effectively move outside of the existing rules of development, then that 5 meeting limit would not apply.
Okay, got it. Thank you for that. And a real quick last one, is reasonable person a legal term?
yes,
It
it is.
It is from the perspective of, some land use entitlements are, if they're subject to legal review, they're looked at from a substantial evidence standard. And that really is kind of a standard of, could a reasonable person make those findings based on the evidence? And it's a somewhat deferential standard. And as was pointed out in the slides, if the city makes findings to deny a project under the HAA and under SB 330, the standard of review and the burden of proof is on the city. And that standard is a preponderance of evidence, which is a higher standard than kind of the substantial evidence, reasonable person standard.
Oh, okay, all right, thank you. I'll save my questions about for the objective design standards till the next part. Thank you.
Right. I guess that leaves out architects, Joseph, under reasonable persons.
Yeah.
But,
Yeah, I know, really, exactly. So I was wondering.
all right. Are there any other questions from the commission?
Charles has one more question.
Sure.
And this is just a follow-up to Brian's question when he talked about somebody has 3 houses and want to combine 3 contiguous lots into 1 house. So presuming in that example that we're zoned for R1 in that area, would SB 330 even apply to such a situation? Or is it only applicable to where we're existing zoning for multifamily or mixed use multifamily?
I think, Claire, I'll defer to you if you know, but I think one of the answers here is we're not 100% sure yet. I hate to give that as the answer. And Claire, I don't know if you would agree with that.
No, I do agree. I was going to say it's the staff report goes into the design review process goes into it a little bit. Our view is that if the project is multiple projects in the R1 zone as one project, that would apply because there's a case that says that if you, for example, if you subdivided lots and you're all single houses on each lot, that's one project that still comes under the HAA. But there is no guidance on whether or not if it's R1 and it's only one house on one lot and that's one project, whether the HAA applies. It's our view that it probably doesn't because that's not really the intent of the law to address house shortages. But the short answer is probably not, but we don't know for sure.
Okay. I just want to make sure that we're not in a situation, and I don't think we are, where an applicant can come in and buy 4 contiguous parcels in a R1 and go, woo, I'm going to build a 4-story 20 apartment building there. I couldn't imagine that's something that could happen.
Well, I think that would require a rezone. So it wouldn't fall under the HAA, and that the city would have the legislative prerogative of whether they wanted to grant a zoning amendment to do that.
Great. Awesome. Thanks.
Okay, so Brian, I guess, is there a part 2 then now to your presentation? Is that what I'm understanding?
There's a part 2 that the planning staff's going to pick up and present on. So I think Claire and I are going to stay on, but kind of go dark and let planning staff jump in.
All right, great. Thank you.
Yeah, Mr. Chair, we would really appreciate both of the attorneys sticking around as they have volunteered, because there may be additional questions for them during this next presentation.
Does that mean you want me on camera, Ken?
Yeah,
Or
Either
we'll
way.
stand by the camera.
either way.
Okay, so do we have the staff presentation? There we go.
Yes, let me get this loaded. All right, good evening, commissioners. My name is Haley Crawford, an associate planner here at the City of Walnut Creek. And so tonight I will be continuing kind of our conversation on SB 330 and the impacts to the design review process. And then my colleague Janine Cavalli will also be providing a progress report on the design guidelines update project. And so I'll be focusing on kind of SB 330, the applicability and process and specific impacts to design review. And then Janine will be giving a project overview, document framework, and schedule on the actual design review guidelines update. I will note I'm going to pause after the SB 330 part of my presentation and ask for questions then before we get into the design review standards piece. And I have about 10 slides, so it hopefully shouldn't take too long there. So I'll try not to kind of repeat what was already said, but more put it in context of a design review application. But essentially SB 330 came into effect January 1st, 2020, with the goal to streamline housing production. And it applies specifically, as we have already discussed, to residential projects, mixed-use developments with 2/3 square footage designated for residential use, and those transitional housing or supportive projects. Does not apply to any project seeking a legislative action, so general plan amendment or rezone. Does not apply to commercial or non-residential, and it has no impacts to CEQA. And so I'll kind of take you through a typical kind of application process. So there's the new concept of the preliminary application. That's the first step. The applicant would submit 17 specific items. If they do that, the application is deemed complete and all the applicable ordinances, policy standards are all locked in at that time. They then have 180 days to submit a planning application. And this is kind of our typical Y number application that you see before you so often. Once that is submitted, the typical 30-day review time starts. And so staff would review that application and determine it to be complete when the applicant has submitted all the necessary items to enable staff to assess the project's compliance with ordinances and policies and standards. And once it's been determined to be complete, then staff looks at compliance. And so staff has 30 days from that point to analyze the actual content of the project and see if it's in compliance with those specific ordinances, standards, and policies. And so a big piece of this is if the project is compliance with the objective design standards. I have the definition up here, which we've already mentioned, but again, a standard that involves no personal or subjective judgment, uniformly verifiable by a reference to an external or uniform benchmark. And so currently, in order to assist both staff and the applicant in kind of getting out what the objective design standards are up front, so everyone kind of knows what we are looking for projects to comply with, staff has created an objective design standards checklist. A page from that checklist is included on the slide, but also the entire checklist was attached to your packet tonight. But that contains all of the existing objective design standards that we have today. So everything from our current 1996 design guidelines and from the 2018 addendum for multifamily, as well as some from specific plans. And so that's what we have right now. When we later on discuss the design guidelines update project that Janine will be discussing, this checklist will get updated once we have new objective design standards. But for now, since we are under SB 330 currently, we are using this checklist to determine compliance. And so if a project is determined to be in compliance with the objective design standards, the zoning, all other policies, then situation number 1 on the screen here occurs, and the project then moves forward to the design review commission for review. If the project is found not to be in compliance, then a few options can occur, and that's situation number 2. So the staff then notifies the applicant that they're not in compliance with, and specifically lists which items they're not in compliance with. And then the applicant can revise the project to comply and then follow situation number 1. The applicant can choose not to make the revisions and then forfeits the benefits of SB 330 and follows just your typical discretionary design review process. Or the applicant can disagree with staff's determination. In that case, the planning manager then makes the final call. And then depending on that call, whether SB 330 then applies or they follow situation 1 again. And so the Design Review Commission's role under SB 330, there are some things that don't change. Design Review Commission is still considering the entire project, looking at site plan, elevations, landscaping. The big one that we've talked about tonight is that the DRC can no longer impose conditions, subjective conditions that would preclude the applicant's ability to achieve the proposed density. And as we talked about, that's both physically and or financially. The DRC, though, can make recommendations or impose subjective conditions if that condition does not impact the proposed density. And it is on the applicant to submit justifications regarding any condition that does impact the density. And we have talked about already, but there is the maximum 5 hearings. And so this 5 hearings does include study sessions, and it also includes appeals. And so in the case of an approval, the Design Review Commission would be making their standard findings, and again, can impose subjective conditions that don't impact the proposed density. However, in the case of a denial or a reduction of density, then that decision must be based on evidence, as Claire and Brian discussed, that the project would have a specific adverse impact on the public health or safety, and that impact cannot be mitigated. So I'll pause there and see if there's any questions or feedback just from that process. I know a lot of it's similar to what we already discussed tonight, but if there's any more, and then again, Janine will be following this up with our design guideline and design review update project and how that process is responding to SB 330.
All right, any questions from the commission? I have one, Haley. That slide where you had going through the design review process, 1 or situation 2, right there. On situation 1, if it's compliant, why are we even going to design review? If they meet all the objective standards, design review is a subjective process. And if we're not allowed to look at site planning or to upgrade materials, what are we doing?
That's a great question, and staff especially spent lots of time discussing that specific issue. And I think there's a couple reasons why we chose kind of this path. The first one being that I think we all find value in the design review process, both applicants and staff, and that there might be suggestions that an applicant would be willing to follow that might not have any impact on density, but there might be some simple site plan, reorienting, maybe some entrances to units, or reorienting a driveway to a different location because it works better with the neighborhood, and that doesn't have any financial impact or any impact to the density, but it does have a positive impact to the project. And we've seen that happen with other projects before. And so we recognize that. The other part of it is that it does keep kind of the transparency with projects, and it allows the public to have an opportunity to comment on projects. And so we felt that was important. And there also is a potential for, subjective conditions to be applied to a project. They just can't have any impact on density. And so we kind of felt that all that together, we did still want projects to go through a design review process, but we do recognize that it's going to look a little different than it does today.
Does the financial costs include soft costs such as design? Because I know the way it goes now, a lot of the plans coming in are almost complete, to meet some of these other assembly bills and so forth. So we make suggestions on site plans where they have to reorientate things. Again, there's a cost there to go back and redesign it with the consultants. So does that fall into the argument? I don't have to do that now. You're pushing my costs up.
It's up to the applicant to kind of provide reasoning or evidence if anything will impact their density. So I would imagine so. I'll defer though to city attorney if they feel otherwise, but I imagine it would all be wrapped up into the project as a whole.
Okay. All right. Again, any other questions from other commissioners? Okay, if not, we'll move on to the second part.
Brian?
Which Brian?
Brian, am I on? It's Joseph. I don't know if I'm on phone audio or computer audio. So I did have a couple of comments on the conjecture design standards.
Okay, I hear you and see you. I'm assuming others do also.
Okay. Yeah, I worked on the objective design guidelines with the city, and one of the things that we discussed was that there was almost like a understanding that developers of Walnut Creek are going to do a good job. They're not going to try to put up a big white box and do something that's, doesn't have some character to it. It's just not the Walnut Creek way. And that was an assumption. And then we looked at things like color and style and realized there was no way you could do an objective design standard on either one of those items. It was almost impossible. And the only way we could have dealt with color was to do a series of swatches on a couple of pages and say, well, pick one of these sets of colors. That's the only way you could make it objective. And so the design guidelines, I did not get copies of it because I'm out of town, but I would encourage everybody to read them and look at what we tried to put together in the guidelines, in that it had more to do with sort of quality of the work, proportions of, you couldn't have 70 feet of wall without some kind of vertical cut, and that vertical cut had to be 6 feet deep so that it actually had an impact. Windows had to be of a certain depth to get some character to the building. There had to be a sense of the top and the bottom and a change in materials. Those were objective the best we could, but I encourage everybody to read the objective standards that we've written so far so we can all comment on them later. Thank you. It's not a question.
Okay, so again, are we going to move into the design review standards now?
Yep, I'll hand it over to Janine to talk
Okay.
about that project update.
Good evening, Chair. Can you hear me?
Yes.
Okay. Good evening, Chair Killian and members of the commission. My name is Janine Cavalli, and I am a senior planner here in the Community Economic Development Department. Also with me this evening, we have on the call Alessandra Lundeen, who is our consultant from Ramey and Associates, who is helping us with the update. I'm coordinating the update to our citywide design review guidelines, and we'll be presenting an overview and status update of the project to you this evening. Next slide. So the purpose of the project is to update and modernize our design review guidelines. Here's showing you that it was adopted in 1996. So we're really looking to, reuse as much of the content as we can, but it will be modified and updated to kind of better reflect what's been occurring in our city in recent years. Focus on some gaps that aren't included in the design review guidelines, such as mixed use development that wasn't contemplated back in 1996. Also modernize the guidelines based on some current best practices, such as the sustainable stormwater management facilities, and to integrate the objective design standards addendum that was adopted for multifamily and SB in 2018 to respond to SB 35 for affordable housing projects. And then also just to create user-friendly, well-organized, better formatted, better graphics in our new updated document. Next slide. So just to give you a little bit of background, so back in 2018, in response to SB 35, we adopted a set of objective design standards as an addendum to the 1996 guidelines. And again, that was in response to the requirement for objective design standards just for affordable housing. When those were adopted, council then provided direction to city staff to come back in a year with an update to the 1996 guidelines, recognizing that that it was time for an update. It was about an over 20-year-old document. So then in 2019, staff worked with our working group, which included members of planning, members of the engineering department, as well as two design review commissioners, Commissioner Gorning, Commissioner Case. So we did a tremendous amount of work that year. We got to about a 2/3 complete document, and then SB 330 came out and basically expanded the scope of objective design standards to not just simply apply to affordable projects, but to market rate residential projects as well. So then at that time, we took a pause and kind of started to dig into all of the legislation that's been presented before you tonight, and to better understand what the implications are for the design review process for the city of Walnut Creek, as well as to better understand how that might impact the work that we were doing to update the guidelines. And so we looked at a revised framework for the updated design guidelines document. Next slide. So we decided to restructure it such that there would be two documents. One would be focused on residential and residential mixed use, and then the other document will focus on non-residential. And that's because, as Haley mentioned earlier, the objective design standards are required for residential. They're not required for non-residential. So these two documents will have a little bit different emphasis. The emphasis of the residential document will be more objective design standards than you'll see in the non-residential. We are going through all of our current guidelines. Some of them are written as guidelines, some of them are written as subjective standards, some of them are written as subjective or objective standards. So we're trying to go through, clean everything up so that if it's a standard, if it's a shall statement, it's going to be objectively written. And so there will be standards in both. It's just that the focus of the residential will be to have more standards than guidelines. Next slide. So as I mentioned before, we want to make this document as user-friendly as possible. So there'll be a lot of emphasis on, tables, photos, graphics, that type of thing. We are looking to organize it into 4 chapters: site planning, architecture, landscaping and trees, and lighting. And then within each chapter, there are a series of topics. So as you see here on the right, under site planning will be things like site access, building placement, parking. Under architecture will be things like materials, building entries, massing, form, and articulation. Next slide. So then under each design topic, the structure will be first to identify the intent. So what is the intent of, in this example here, what is the intent of lighting design? So that we then can see that those guidelines, those standards support that intent. So the distinction between standards and guidelines is that the standards are the priority design criteria that all projects must follow. And these are typically written with shall statements. And then the guidelines are strongly recommended design criteria with which projects should comply. There's greater flexibility there, and these are typically written as should statements. Next slide. So again, the standards are all going to be written objectively. They'll be required for projects that are requesting approval pursuant to provision of state law. So any project that's going through the SB 330 route, the objective design standards are what is applicable and what they'll be checked in compliance against. They're treated as the priority design criteria, so that all projects should comply with for non-SB 330 projects. So again, as I mentioned before, we will still have standards for non-SB 330 projects, but they're just treated a little bit more as guidelines than they are treated as standards if someone's going to go through our typical discretionary review process. Again, our document today does have both guidelines and standards in them, but they still both go to the Design Review Commission for review. The objective design standards will be included as appendices in the document. So it's a simple user-friendly checklist. So that if a project that is going through SB 330, there's just this a user-friendly checklist that we can hand over to applicants over the counter. Next slide. So this is an example. We pulled these, I think that we pulled these out of our existing guidelines to kind of demonstrate what could be written as a standard versus what needs to be a guideline. So starting with the standard on top, pedestrian-oriented lighting shall be placed along multi-use paths. So that's stating that if you're going to have a path, if you're going to have a walkway, there needs to be pedestrian-oriented lighting along it. Whereas the guideline is going to be less objectively written. Raised light pole bases should be attractively designed and well detailed to be compatible with the overall project. That could be interpreted a myriad of different ways. That's more subjective. It's not something that can be, objectively understood. Not every single person that interprets that will interpret that the same way. So that's why that would then become a guideline and not a standard.
Can I ask you a question?
Yeah.
But if we wanted to, I just want to make sure this wouldn't be against SB 330 in this example. If we wanted the standard to say the use of concrete form pole bases is prohibited, we could do that, right?
Correct.
Okay, thank you.
Yes. Okay, sorry, next slide. So we we have, as I mentioned before, we have a city working group. We've kind of put pause on that as we tried to work through a lot of the implications of these new state laws. That working group has helped us get through maybe about 70% of all of our guidelines and standards. But again, when we were looking at that, that was with the understanding that objective design standards only applied to affordable housing projects. Now the scope of that has expanded to all residential projects. So we want to go back and take a fresh look at the standards and the guidelines that we've written to date with that new understanding. And then we also have the rest of the guidelines to complete. So we will be coming back to reconvening with our city working group shortly. Next slide. So when we started the project last February, we did have a couple of focus group meetings. We intend to do that again here shortly in the fall, have another meeting with our developers forum with this kind of rebooted project to kind of go over some of the highlights of what we've gone over with you today about what the new design review process is and what the new document will look like. We also last year held a social media contest where people could submit photos of their favorite buildings and design features just to get a little bit of momentum going around the project and get a little bit more education out there about what the importance of design guidelines. Once we do have a public draft or leading up to the public draft, we also have a set of folks who volunteered to be testers of the document to make sure it is user-friendly, because that is one of our goals. So what we have identified a group of folks that that are going to be reviewing the document for that purpose for us. We're hoping to have a public draft this winter and then adoption hearings in the spring. Next slide. So next steps, we were just awarded a LEAP grant in the amount of $200,000 to for both staff as well as to work with our consultant and extend their contract. Now that we have kind of a larger scope of work here, looking back at all of the language and the content with this new understanding of objective design standards. So we're currently working with the consultants to revise the guidelines and standards. And then, as I mentioned, we'll reconvene the working group meetings and aiming for a public draft this winter. So I think that's everything. Is that the last slide? Yeah. So again, happy to take your questions.
All right, thank you. Any questions for Janine? I have one, Janine. Is the in the design guidelines, will there be a definition section to what, for example, pedestrian lighting? What does that mean? Is that a bollard lighting, or could it be a sconce lighting off of a house or something? So, I mean, we're getting so locked in on these objective standards. I'm just kind of curious how we're defining some of this so we know exactly what's what.
Yeah, no, I think that's a good comment to have, either, like a glossary, or when we're using these terms, if we're being very specific about what we mean when we use those terms. So I think that's just a good comment more broadly for the entire document to be mindful of that.
And is there a way for the developer now, a checklist, if he goes through the objective standards and meets everything, that they can bypass the design review?
So basically the process that Haley outlined is the process that we'll be using from here on forward. So if someone comes in tomorrow and they meet all of the objective design standards, the intent is still to have a study session with the Design Review Commission to offer your input. again, you know, they don't necessarily have to follow the recommendation of the Design Review Commission if they've met all of the objective design standards. But the understanding from our experience here at the City of Walnut Creek is that developers do respect the comments from the Design Review Commission and the public and the community, and want to have a project that is supported. So that's why, as Haley mentioned earlier, you know, even though we went back and forth with, you know, should we still bring it to DRC even if they meet everything, that's why we came out with the recommendation to, yes, still have a study session to give you that opportunity to provide input.
I see. All right, thank you. Okay, again, any other questions from the commission?
I have one comment when you get a chance.
Sure, let me, Joseph, let me open this
Yeah.
up to the public first.
Okay.
And then we'll come back for comments. So if there's no other questions at this point, I'd like to open it up to the public. Again, if the public would like to join in, let me read the ID number is 915-0784-9742. The password is 999727. I guess, Ken, I'll rely on you to let us know if anybody
Yeah, Mr.
has
Chair,
any comments from the public.
we'll wait a few seconds on that, and this would be public comment taken on both items 5A and 5B. Okay, I'm not seeing anyone coming in, so I guess we can go ahead and close the hearing, Brian.
Okay, I'll close the public portion of this and bring it back to the commission. We'll kind of keep it informal, I guess, but if there's any comments or additional questions of the staff too. So Joseph, you had a comment?
Yeah, my only comment, you can hear me, yes? Can you
Yes.
hear me?
Yeah.
Okay. My only comment is that one of the issues that came up with the design standards in Walnut Creek was that we were doing the north downtown specific plan and the west downtown specific plan, and each one of them had their own set of design guidelines that were starting to be baked into each one of them. And it was made a decision by staff, I believe, and council to not have separate design guidelines for those two projects and kind of wrap it into this one. So I think it'll make things a lot more straightforward for the developers. That's it.
All right. Okay, any other comments from the other commissioners?
Yeah, Charles here. I have two comments. One, I'm glad you're keeping DRC in the loop, because I think one benefit the DRC can have, even though we may have some of our authority stripped due to this law, is it's another set of eyes over, do we think the applicant actually met the objective guidelines? So maybe on the off chance we see something the staff didn't see, that can add a little value to the process. And then just my other comment is, and it's sort of repetitive, which is, it really seems to me, if it's important to the city to have as much design review input and control over the process as possible, that if assuming we have the people power, budget, et cetera, and the desire, the objective design review guidelines probably have to be exponentially increased, more robust, so that we can think of all the things we don't want to go wrong, that the Design Review Commission over the years have, there's probably all these things that they've come up with over the years collectively that probably need to be memorialized in objective design guidelines. I just don't know that we have the time or the people power. I'm hoping that we do. Those are my comments. Thank you.
All right, great. Casey, Carlos?
No, I still think our role has been diminished, and we lost part of our leverage in this project. But let's see how it works.
Casey, you're muted. I don't know if you're doing that on, okay, there you go.
Oh, I don't have any questions or comments.
Okay. My only comment is, I kind of agree with Carlos, but you know, if it's going this way and the objective standards, you know, is such that it's complete, I don't want to waste the developer's time or our time going through a process that has no meaning, that we're just paper tigers and we're reviewing it, but we really can't change anything because the state says thou shalt be. Let's cut it out. I mean, why prolong the process? You know, unless we have some valid input, you know, with conditions of approval that hopefully will improve the project. But if we're just sending it through the design review commission as another step just to review the objective standards, you know, I think that's kind of a waste of time. But again, I guess we'll see how it goes. So with that, if there's no other comments, Ken, I guess we're just here to listen at this point. We're not making any.
That's correct. Just to listen.
Motions or anything?
Yeah, and Brian, you bring up a good point. We went round and round on the effects that this new state law was going to have on our ability to review projects. And you're exactly right. I mean, there were some of us that argued that just that. Why are we even coming to Design Review Commission if they meet all of the requirements? I think we landed on, you know, the Design Review Commission deserves to look at a project, even though it meets all of these particular standards. There may be aspects to the project that would benefit from coming before this commission, and that's what we wanted to make sure that we that we provided. So and remember too that this only affects residential and and mixed use projects of 2 or more units. So all of the commercial, all of the community facility, whatever, all of that is not affected. This only refers to residential and the need that the state has identified to provide as much housing as we can, as fast as we can. So you maybe just keep that in mind as well.
And then lastly, that if projects don't comply with our policies, standards, et cetera, they would go through the typical design review process that you're used to today.
Okay. Okay, with that, let's close this out and move back to 4 public hearings. We have 1 project tonight. It's the Waymark Building Master Sign Program. And if we could have a staff report, please.
Good evening, commissioners. Let me just load the presentation. Hello, everyone. For the record, are you able to see me?
We see your slide. Yes.
Great, yeah. For the record, my name is Simmer Gill. I'm an assistant planner with the City of Walnut Creek, and we are here tonight to discuss the Walnut Creek Transit Village Master Sign Program for the Waymark building that will be located at 101 Pringle Avenue. Design review application number Y20-024. The applicants representing the project, Eileen Ash and Marlo Folgado, are here tonight, as am I, to answer any questions that you may have after the presentation. Here is the site location. The vacant parcel is located directly across the way from the Ignacio Center building and north of the existing BART parking garage. The surrounding area consists of retail, residential, and office uses. And the master sign program is for the new Waymark development that will consist of 2 multifamily mixed-use buildings with 358 apartment units that will be constructed over a underground parking garage. These improvements are currently under construction. The sign table that you see on this slide identifies the square footage, the illumination, and locations of all the proposed identification signs that are identified as number 1, 2, and 10 on this exhibit. Those are the primary wall identification signs proposed. There are also 8 retail tenant spaces that will require signage, and we will discuss those later in the presentation. The remaining sign locations that you see on this exhibit are residential, pedestrian, and wayfinding signs that consist of wall-mounted signs, directional and courtyard signs, and also parking garage signs. The parking garage sign located along Station Way is for residential parking only, and then the other parking garage sign that's located along Pringle Avenue is for residential and for for customers for the tenant shops. And all of the tenant shops will be located along Pringle Avenue and North California in this corner here. And I won't spend too much time on these particular signs as they conform to the city sign regulations, and they help in directing resident and visitors to the site, to the parking garage, and also to these retail shops. The sign subcommittee on June 3rd of this year did review the master sign program, and we're in support of the master sign program and sign ordinance exceptions with some minor comments addressing the following. The subcommittee requested more detail and integration of the clock surround, and they also wanted photographs or renderings of day and night renderings of the clock, and also provide more options for the corner retail tenant, and provide details for tenant logos, and also to shield the vertical wall sign and logo from the residential windows that will be located on the southeast corner of the building, again at the corner of Pringle Avenue and North California Boulevard. And now moving on to the proposed wall signs. Here is the image of the primary wall sign that will be located on the southwest building elevation, which is identified as the rails and station building in the project plans. The signs consist of black halo, this sign consists of black halo lit reverse channel letters that will be 2 feet in height and 22 feet 11 inches in length, and total 48 square feet. And a 44 square foot clock ID sign will be mounted directly above this project ID sign, as you can see on this rendering. And the clock ID consists of a fabricated aluminum cabinet with a soft white internally illuminated clock face with the analog design. And the clock, and this is a rendering that was previously submitted that the subcommittee saw. Initially, the clock sat on the face of the parapet as opposed to being integrated into this arched parapet. The science subcommittee requested the applicant to anchor the clock to the fascia of the building. The revised plans now do show that the surround detail has been more recessed and integrated detail around the clock. Staff supports the project ID and the clock ID sign as it can be viewed as an architectural feature, which not only provides identification and also complements the building facade. Please note that the sightline study that is sheet 11 of the plans, and I've included it here, was developed earlier, and it does not clearly show that sunken in clock detail. The clock ID sign will be fully integrated into the parapet, and it does not extend out as seen on this sightline study. So it does not line up with the primary Waymark sign. It's actually sunken into this parapet. And I don't have a side elevation of this, so this is the best rendering I have to show that it is integrated. And here are the other 2 wall signs that will be located on the southeast corner of the Trails building that is located at the corner of Pringle Avenue in North California. A 17 square foot wall sign with halo lit letters and a 7 square foot logo will be pin mounted to the building walls as seen on this rendering. The black vertically oriented letters will be 1 feet 2 inches in height and 13 feet 9 inches in length. The science subcommittee did express concerns with the location of this logo on the left building wall, as is mounted on a building wall which has a very narrow width, and it's in very close proximity to the upper story residential windows that you see here. The applicant has included a dimmer switch in order to control the light levels. And if approved, a condition of approval has been included in the reso that the illumination for both of these signs, the logo and the vertical sign, be turned off at 11 p.m. daily to avoid any potential glare issues to the adjacent residential tenants. Staff supports these signs with this condition. And now moving on to the retail signs, a total of 8 retail tenant spaces are proposed along the ground floor of this building. The tenant sign will consist of fabricated aluminum channel letters that will be pin mounted on top of the canopy rails above the storefront entry doors with a maximum letter height of 18 inches as illustrated on these renderings. Each tenant is allowed one primary identification sign, one non-illuminated blade sign, and one window graphic sign. The sign subcommittee requested the applicant provide additional details for tenant logos. So this option here has been included, and the size of the logo and letters is limited to 18 inches to be consistent with the options 1 and 2 that are illustrated on the slide. Staff supports the tenant signage as the sign criteria complies with the city sign ordinance and suits the design character of the proposed mixed-use development. And here is a view of retail tenant space number 2. The retail tenant location map that I've included here indicates a very consistent and compatible appearance for 7 of the 8 tenants. However, additional sign creativity can be considered for this tenant space as it's a curved, much taller storefront, occupies a larger tenant space, and is the focal point of the Waymark development. The sign subcommittee requested the applicant to also consider a more creative sign option as opposed to the standard 18-inch tall letter size. And this space does have unique architecture that sets it apart from the rest of the tenants. Staff would like DRC to comment on this if there is a need for other options, additional sign options for this location. The applicant has included the second option that you see here, which illustrates a larger sign that occupies the majority of that curved canopy and appears somewhat different from the standard sign option. However, no size, dimension, or illumination was provided as part of this submittal. Staff believes having more than one option for this tenant space could avoid any future master sign program amendments or changes, as any modification to the master sign program requested by the future tenants will require a design review, commission review, and approval. And staff is anticipating that due to the prominent corner that there will be changes requested for signage on this tenant space. In the next few slides, I will go over the sign ordinance exceptions that are requested for the wall signs. These same signs will also require the DRC to make findings to allow the signs to be located higher than 25 feet on the building walls. And this 45 square foot project ID wall sign will be pin mounted at 40 feet 5 inches from grade, and the 44 square foot clock ID will be located at 48 feet above grade. And this is to easily identify the building from the BART station and the adjacent BART tracks. And here is the 17 square foot wall sign and logo that will be pin mounted at 43 feet above grade to the southeast corners of the building wall. The building corner with this curved facade along the lower level will be the focal point for all of the retail shops that are surrounding it. Both the logo and project ID signs are located higher than 25 feet from grade and will require the DRC to make the findings to allow the sign heights and the sign exceptions to allow more than one 24 square foot wall sign for a multifamily development. Again, they're proposing a total of 3 wall signs and one logo. Staff supports the sign ordinance exceptions as this is a large project at a prominent corner, and visibility could be blocked due to the existing BART tracks if the signs were any smaller or located any lower. Additionally, due to the existing exterior windows and the architecture of this building, there isn't really any other place to install the wall signs. The sign subcommittee also supported these higher signs when reviewed at subcommittee. And just to summarize, sign subcommittee and staff are supportive of the requested sign ordinance exceptions and the wall sign heights above 25 feet from grade, as all the signs have been designed to complement the building materials and to enhance the identification and wayfinding of the development. This is a larger project that's located in a mixed-use zone where more signs are typical for adjacent transit and surrounding uses. And other similar projects like the Via, the Brio, and also the Arroyo apartments were also granted sign exceptions from the DRC for the size and number of wall signs due to the nature of the project size and the zoning and the location of those buildings, which is very similar to this building. Also, the architecture of the buildings and placement of the windows doesn't really allow for any logical placement of a wall sign any lower, while providing sufficient identification to the BART users or motorists traveling along North California Boulevard. And finally, the project ID signs are in scale, and they improve the architectural appearance of the building and also assist in identifying the location of the development while maintaining a design that reflects the character of the area. And with that, staff recommends that the Design Review Commission approve the master sign program, the sign ordinance exceptions, the wall sign heights over 25 feet above grade for the Waymark building, subject to the attached conditions of approval for design review application number Y20-024. And with that, I conclude my presentation and will be here to answer any questions that you have. Thank you.
All right, great. Thank you, Simmer. All right, do we have any questions of staff?
I have a
Casey?
question. Yeah. So I'm guessing that the latest proposed clock is the one with the Roman numerals, but in some of the renderings, it looks different. Can you just confirm which clock face we're planning to see?
The clock face will be the Roman numerals.
Okay. Okay.
And the other ones were the renderings, and yeah, they don't depict it correctly.
Right. Okay. Okay. Thank you. That was my question.
All right. Any other questions for staff?
I think Commissioner Gorney has a question.
Yeah, I think we had a question from
Joseph?
Commissioner
I can't see you, Joseph, so chime in if you're.
Joseph, you're muted.
Joseph's on mute.
All right, well, he's figuring that out. Why don't we have the applicant, if you have an presentation, and then we'll figure out Joseph as we go along.
So yes, Eileen Ash is here representing the project. I don't think she has a presentation, but we'll be here to answer any questions.
Okay, great. All right, Joseph, are you back with us?
Oh,
Always trying to figure you out, Joseph. All right, any other questions of the commission to the applicant? I don't see any. I have a couple.
Okay,
then.
how about this? How about through the phone? Is that working?
Oh, there you go. I hear you
Okay,
now.
good. Again, it's got a mute on the screen and it's got a mute on the phone, so both of them are different. So, question. I love the new sign with the clock. It's much more sophisticated than the old one we got originally. You have that kind of curve that goes under the clock. There's like the little bottom. Is that a reglet or is it like built out? Because it feels a little tight to the sign below it, but I can't tell if that's a build out or whether it's flush with just kind of a reglet line. Does that make sense at all? Maybe you could pull up the picture with the clock on it.
Yeah, I can.
Yeah, I'll try to speak to that in that I'm going to just say that
Sorry, I'm not able to share the screen again.
We're at a schematic design level, and as upon your approval, we'll move into kind of the finished details with the design team, and so we will resolve any of those questions.
Okay, so you're going to look at that proportion. It seems like the Wayfair sign is pushed down a little bit under the clock. It seems a little tight to that fascia, so you're going to adjust that as you go, correct?
Right.
Okay. The sign, the Waymark, at the vertical one on the edge of the building, is that normally the way you would do it, where the sign always goes top to bottom like that versus bottom? It looked backwards to me for some reason, but is this how you would normally do it, like reading it top to bottom?
Marlo, do you want to speak to that? I mean, this is one of the scheme that
I don't know
was
why my
presented
brain
to
looks
us.
like it
That,
was upside down, but I'm just asking
that
if
we
this
like.
is normally the way you would do it.
Sure. The way we designed to read from top to bottom is, I guess our inspiration was just the spine of a book. As far as just how it's vertically aligned and it's read from top to bottom.
Okay, it seemed odd to me, but I get it. And maybe go back to that last picture you had with the clock, just so I can make sure that we're clear. Simmer?
Yes.
That one. Because it looks, lost it again. Boom, there it is. Because it looks like the sign is pushed down quite a bit, because it looks like there's a line behind the word Waymark, and it kind of feels like it's pushed down a little bit, and then there's that curved line right there where the cursor is. And if that's a reglet line versus being pushed in or pushed out, I think it makes a big difference. So I just think you need to study that a little bit to make it look right. See if anybody else agrees.
We will do so.
Right.
Okay, because you can't really tell where that fascia returns back again. I'm assuming it's the second line under there above the windows versus the upper line. It's just going to make sure there's enough space there below the lettering to make it feel correct. And you can even go up, if that was flush to that circle, it could almost go up a little bit and, cross that circle. I don't think that would be a problem if they kind of intersected each other. That's it. It's more comment / I really like this. It's much better than the original. Thank you.
This is Brian. Let me stay on the clock issue. Just in the perspective, it appears that the arch of the clock there is going above the highest element. Is that just a perspective to where the that element is set back and the clock is kind of freestanding?
That is correct. So that clock element sits with the flush with the face of the building, and then that is a step back wall and parapet.
So is there depth to the surround around the clock? Like, is that 6 inches wide, or is that just being proud in front of that upper fascia?
Yeah, I would anticipate it'll be a minimum of 6 inches wide because it'll match up with the parapet thickness.
Okay, but it's standing alone, right? If I'm understanding that correctly.
Well, standing alone, but springing from that parapet that it be resting on. Right.
Okay. I only had one question for myself. The Waymark logo next to the residential window. Now, I don't know, I may be getting old, but I'm going to bed at 10 o'clock. If the idea for the dimmer is to not conflict with the residential window, do you have any problem with maybe 10 o'clock rather than 11 o'clock? And I don't know if stores are open that late or anything, but what was the rationale for 11 o'clock to dim the sign?
Yeah, I think we just said 11 o'clock because most shops close at, I would say, 10 or before 11. Some restaurants are open till 10 p.m. And if there's going to be a restaurant that's going to go in that lower tenant space, we selected 11 p.m. as the correct time.
But the reason for the dimmer is not to disturb the residents, though, correct?
Correct. I guess we're flexible on that, right, Eileen? We can.
What time is the last BART train?
That's really late.
That's late.
Midnight.
All right. Well, maybe we can iron that out on the conditions or on the motion. So does anybody else have any questions of the applicant?
Hey, Brian, can I dovetail on your question on that sign?
Sure.
When I see the picture of it, it's very different than what's in the rendering. Is it a white box that's lit with some black lettering in it? Or is it like halo lit behind the letters and the track?
It's halo lit, yeah.
Okay, so it's not a big white box with some black letters on it. Okay.
That's correct.
Thank you.
Okay.
I had one more quick question on some of the entry ID signs. Is that appropriate to ask now?
Sure.
So it's just for curiosity. In the background, in my package, I can see the Waymark residence and guest signs and a couple of these other ones that had like a black background. almost has like a marble-esque chalkboard kind of look to it. And I wasn't sure again if that's just rendering, or is that going to be a flat black, or does it have kind of this integrity to it? I don't know how to articulate that. It's on page 22 of my package, is just one of them, but there's a couple that have that background.
Hi, I'm sorry, I lost my feed there for a moment. I apologize.
There's some ID signs. The one in particular I'm looking at is on page 22, and it says the Waymark residents and guests. And in the background, the black element has kind of this almost chalkboardy or kind of mottled marble look. And I just wanted to know, is it going to have that kind of feature, or is it just a flat black? That's what I was curious about. I'm looking at the
Is that the blade signs you're looking at?
there is, yeah, one of them is a blade sign. The one I'm looking at is number 9. I saw the feature on several of them. It's also number 8. Just scrolling around now. Yeah, blade signs too. Yeah. And then the site map. It's basically anywhere there's that black background. I was just curious. Is that question making sense?
Yeah. So the question is, what's the background, correct?
Yeah, because when I look at the materials page, I don't see that kind of smokiness, right? But I'm also looking at it on a digital screen, so it's hard to tell. I was just curious if it's going to be a flat black, or if it's going to have some of this dusty chalkboard, smoky look.
Marlo, are you able to address that for us, please?
Yes. The intent, or what's shown on the materials page, is going to be a flat, like a dark gray satin finish. But what we didn't update or include in the materials as an option, and it is shown in the background of a handful of these signs, was like a black and see, like a faux finish almost, as our original intent. But right now, what we're showing in the color materials page is just a satin, a solid color, a dark gray.
Okay.
All
I
right,
like that.
Carl, do you have more questions, Casey?
Nope, that was all. Thank you.
Carlos or Charles?
No, I'm good. I mean, we reviewed this project not too long ago. I think it's improved.
Okay, if there's no questions, then I'm going to open it up to the public. The public who would like to make comment or ask questions. Again, I'll give out the ID is 915-0784-9742. Password is 999727.
And Mr. Chair, while we're waiting on that delay, we do have some material samples that I have with me. If you're interested, we can try and get the camera to work here in the council chamber. If you'd like to try and see a close-up of any of those samples that we have.
Well, let's give it a shot.
All right, we'll try and give that a shot. Hang on. Oops. And then Kristen, you've got nothing, right? We've got nobody chiming in on the public hotline either. So just to let you know that.
Okay. Why don't we do this? I'm going to close the public hearing then. And then as you're trying to bring up the materials board, why don't we go right into comments from the commission? So if anybody would like to start, feel free.
I can start. So I like it. I really like the look of how it all weaves together, and it's got this feel and charm that I really like. I like the changes to the clock. I like that it's going to be the Roman numerals. I kind of liked the like dusty chalkboard look, but I just think it looks really nice. I think it's cohesive, and I took a look at the locations, and it seems to be fitting and appropriate to me. So that's all from me.
Charles, let's go to you.
Yeah, thanks. So this is because I'm new. This is one of those projects where I'm coming in, midstream. So I will say, number one, the overall project, I really, really like the overall project. I think it's really nice from the renderings and everything I've seen in my package. And then, all I can say about the signs is that our esteemed sign subcommittee did a great job. I think it looks really awesome too. When I went through all the package, I was like, this really all looks great. So that's it. Thank you.
Great. Carlos?
Well, Charles, it was little we did. I mean, it was a very good sign designer who was in front of the project, and kudos to him and her or to the group. I think it's an excellent building, and I think the signage is subdued. It's not trying to say I'm here, I'm the signage, I'm the most important thing. I think the building is outstanding, and the sign is there to actually communicate what it has to communicate.
Okay, Joseph. Again, you might, I think staff was looking too, whether we had any concerns on the square footage and the height. It appears from what I'm hearing so far, nobody has a concern with those issues. Okay, Joseph?
Yeah, I'll be brief. No, I agree. I think sign subcommittee and staff did a really good job on this. And I will say that the clock and that whole sign and getting rid of the rails to trails kind of bracket on the top of the building, this is much more elegant. I think it really works a lot better. And the alternate clock definitely looks like it was pinned on and stuck on. So this is a much better solution. I think the wayfinding signage is really, really well done. It's very urban. And I think it's a good look for this building. The gold leaf letters, I think it's kind of very sophisticated. You don't see that much anymore. And I think it goes with the type of architecture in a way that they're trying to do it. But it's very subdued and very well done. I prefer the black daytime signs. I don't know how everybody else feels about that. I think it's more compatible with the wayfinding signs and the other signs on the project. I think the sign on the curve for the tenant really depends on the tenant. This is a tough one, to show that one with the with the cow on it is fine, but really depends on who's going to go in there. So if there's a way to be able to describe that as a larger sign somehow, but I almost think that whoever that is going to wind up coming back to sign subcommittee anyway, because I think it's going to be hard to delineate exactly what you can do on that curve, depending on who goes in. And so maybe they went larger letters because it's a smaller name. I think it's going to have to be dealt with. And then as we go, it's going to be hard to make recommendations. And I'm okay with the heights on this and the size of the signs.
All right. I can't add anything to that, so I won't. So let's see if we can put together a motion. This is up for final on the sign program.
I'll make a motion that we approve this signage program with the black daytime signs, and that, that we, I think we can leave it to staff to work with the applicant to try to finalize that another option for that curved sign. But if they can't, then to just say that sign comes back to the sign subcommittee because it's a special situation. And basically that's it. Everything else is fine.
All right. Do we have a second?
I second that.
Okay. Before we have a motion, is there any consideration on the timing for the dimmer switch on that one sign next to the?
Oh.
This is Charles.
He can reach out his window and just hit it with a hammer.
Yeah. Wait, is that a condition?
Can we go to 10:30?
Can I ask you a
question? It's one of those things.
If
somebody's living there and they complain about it, I'm assuming a couple people will complain about it, and they're going to talk to the people that work there, and they're going to change it. So at the moment, I'm okay with 11, but I think it'll become an issue with the management.
Is there a feasibility that if it's going to be a condition, you got your full brightness, then there's a certain point at night where you say we're going to really dim it, so it's still lit, but it's not blinding in the windows, and then there's the next clip where it turns off.
I don't know, Simmer, is that, I just understood it would be dimmed at right now at 11 o'clock. Does it go completely off at a certain time?
It's off.
Yeah, I think we identified it to go off at 11 p.m., but I'm sure we can modify that condition to say that it goes dim at 7 or 8 p.m. Like it goes like less, like the intensity of the brightness is reduced.
That's weird.
11 turns
It's weird
off.
because we're dimming it at the time you want it to be brighter. You know, it's almost like it has to be a photovoltaic thing that, you know, when it first starts, the sun's going down, it comes on, and then as it gets darker, it lightens up. This is a tough one. I don't see a way to control it in a motion. Anybody else have a suggestion?
Yeah, and I would hate to pit the residents against the, you know, their concerns with their private residents versus the building's operation, you know, marketing. You know, so I'm not so in agreement.
11 o'clock is pretty late. I'm going to change the motion to say 10 o'clock.
Okay. Does the seconder agree? I think that was you, Carlos.
Yeah, I second it. Yes, I agree.
All right. With that, can we have a roll call, Ken?
All right, we have a motion and a second. Commissioner Gorney,
Yes.
Commissioner Valia,
Yes.
Commissioner Krelling,
Yes.
Vice Chair Case,
Yes.
and Chair Killian.
Yes.
Motion carries unanimously.
All right. Thank you very much. All right, with that, we've already dealt with item number 5. And so we're on to item number 6, which is the commission member and staff reports. Do we have any?
Anything from the commissioners?
Charles here. I just want to add, I forgot to add when I was complimenting everybody, I left staff out on the sign program. Everyone did a great job. So I want to make sure I didn't leave the hardworking staff out. That's it.
Okay. I have one comment. I don't understand. We've done this before where we allow staff to move up in the public hearing to do their work first, even though they're supposed to be second on the agenda, which I don't think is fair to the applicant that's paying all their consultants to wait for this meeting. We've done it in real meetings. We've done it online. And I just think if the applicant, you know, the city can wait. And I think the applicant should have gone first today. I mean, with the Wayfair signage should have gone before the city today.
Okay, so noted.
Okay, any other announcements?
Mr. Chair, I just wanted to remind everyone that this Friday, the mayor will be holding I guess they're still calling it a breakfast meeting. It's the quarterly breakfast meeting without any food this time. We're going to do a Zoom meeting Friday morning at 9 o'clock. And Charles has graciously volunteered to sit in and represent the commission. So he will be doing that. Joseph, did you say you might be joining? Or?
Highly doubtful.
Okay. It's no problem. Charles and I will represent, and we'll let you know what transpires. But this will be a kind of a new experiment with everybody on Zoom. So we'll see how that goes Friday at 9.
All right. Maybe they'll come up with a bacon flavored screen or something to
There you
experience your breakfast.
Well, you know, I had, they could do something like I had a vendor reach out and say, you know, if you're willing to meet with us, we'll send you a Starbucks gift card and you can have your coffee on us for our meeting.
Okay.
Maybe they can send us McDonald's gift cards.
Oh, there you go. Maybe Susie could do DoorDash for everybody. How's that?
DoorDash Sunrise.
Sounds like product placement. I don't know.
Okay, with that, we're on to item number 7. We're adjourned. Thank you very much, everyone.
Thank you.
Everybody.
Bye, guys. Good night.